Welcome back to Hack Your Hazcom. With me today is Adele Abrams. She is an attorney with an associate safety professional and certified mine safety professional, as well as she's senior counsel at Littler Mendelson, a PC based in Washington, D.C., where she represents employers in OSHA and MSHA litigation nationwide, and also handles employment law matters in a large number of states. She also provides employment and safety law consultation, safety audits, industrial hygiene assistance, and training services to companies in a variety of industries. She's co-authored several textbooks on employment law, occupational and mine safety and health, and is a regular columnist on safety law issues for multiple magazines. Most importantly, and in her spare time, she's a rock and roll DJ. That's pretty cool.
Yeah,
Love it. It's important for spare time stuff
it's
to
good
do.
to have balance in your life, right?
That's right. That's right. Well, Adele, thank you for coming today. I thought it was very important for many of my listeners that love to hear about the ongoings of our Hazcom world. And with my audience, it's very important to know about what's happening in the world of law, litigation. And I know you've probably been following this Allstates Refractory case from 2024, which I believe, if the courts do decide, it could mean that OSHA lacks the statutory authority to issue standards. Will this impact Hazcom in any way? And do we expect that to vanish overnight?
Well, I'm going to give you maybe a complicated answer to a simple question here. But the Allstates Refractories case came to the Supreme Court and they denied certiorari, but critically, two of the justices, Thomas and Gorsuch, had urged the other justices to grant it, and in a very unusual situation, they wrote a dissent explaining why they agreed that OSHA lacks the authority to promulgate most of the regulations that they have already promulgated, and that it is a violation of the non-delegation doctrine under the Constitution. Now, what happened was Thomas and Gorsuch kind of invited a new case, and that new case is nearly at the cusp of going to the court. So here's the situation. The first one was in the Sixth Circuit, and OSHA won that round, and Allstates Refractories appealed it. The new case has been brought in Texas, of course, because that is a very business-friendly circuit, the Fifth Circuit. And so the case involves the Texas Agricultural Producers Association, I think it is, and a couple of other business groups. And it's the same argument, basically couched in a bit of a different way, but that any of the OSHA regulations that were promulgated, other than the ones that were adopted from the ANSI standards back in the early 1970s, and that was directed by Congress. They gave OSHA kind of an ollie in free in terms of, grab the ANSI standards, make them the mays must, make the shells shoulds, and you have some standards to enforce because they had just created this agency that had no regulations to enforce. And beyond that, though, what this case is essentially saying is every rule that OSHA has since promulgated under its general rulemaking authority in the OSHA Act, those are invalid rules. And there's a couple of side things to this, one of which is we are in a deregulatory environment right now. And we're waiting for the new regulatory agenda to come out. I kind of hoped it might have come out before we taped this, but you do what you do. Maybe we'll revisit it after that. But there's when they invited deregulatory suggestions from the general regulated community, that is one of the things that they put in their deregulatory request. And by they, I mean OSHA and also MSHA. They actively solicited input from the regulated community on what rules should be killed on a variety of grounds, Some of them, the cost versus the benefits. But specifically, they said any rules that you think violate the non-delegation doctrine. And so that the next regulatory agenda, which should come out this spring, we're still in the spring, that will be, I think, a bit of a tell in terms of where they're going to be going with this. But to give the listeners who maybe aren't lawyers, which I hope is most of your audience, because then I can get away with stuff now. But simply put, Congress, to use the EPA as an analogy, when the EPA was created, same year as OSHA, very similar statutes. Instead of the EPA just sitting around, and maybe having some stakeholder meetings and going, what do you think we should regulate next? What happened was Congress adopted certain additional statutes. They adopted the Clean Air Act, and in the Clean Air Act, and I'm paraphrasing here, Congress said, go forth, EPA, and promulgate some air regs. And then Congress adopted the Clean Water Act and, again, go forth and promulgate some water regs. And all the way up to 2016, when they redid the Toxic Substances Control Act, and that required EPA to then promulgate new regulations. And so this has happened, every step of the way. And sometimes if EPA, for example, gets a little bit out of its lane, there's been some slapback saying, whoa, the Clean Air Act, or, it didn't regulate this. It only regulated that. And, the risk management rule, for example, was back in the day was under some attack for that reason. When they were looking at adding explosives taggants, under that rule. It's like, wait a minute, that's ATF's bailiwick. EPA has nothing to do with explosives taggants. And so, there have been corrective actions done in the EPA aisle. Excuse me. What's happened with OSHA is after the organic statute was passed in 1970, that was it. OSHA has just been on a spree, some might say, promulgating regulations without any specific delegated authority in a specific area. Congress never said, do a Hazcom standard. They never said, do a confined space rule. They never said, do a crane standard. And, it goes on and on for, respirable crystal and silica. They never directed OSHA with specificity to do that. Now, by comparison, there have been a couple of attempts in Congress to direct OSHA to promulgate rules, and one was on workplace violence. There were a bunch of hearings on that, for the healthcare and social services sector. We still don't have a rule, but and the bill to require OSHA to do a rule never passed Congress. Same thing with heat illness prevention. OSHA is working on a rule. There were hearings on that, but because of the political constitution of Congress right now, there's not going to be any rules passed, any laws passed directing OSHA to promulgate any rules. And in fact, it's been quite the opposite. We've had in Republican-controlled Congresses the deregulatory efforts, such as killing the Clinton-era ergonomics standard, killing the repeat violations rule out of the Obama. This is using the Congressional Review Act. They use it, not as a blunt object, but, as a targeted tool. But, that is out there. And, when you look at it in terms of OSHA, Congress has killed more rules than they've actually directed them to promulgate. And I do want to make a little bit of a correction, because there's probably somebody out there who's looking at the Federal Register right now and going, she misspoke. There actually was a Hazcom rule promulgated in Congress and passed back in, I think, the 1990s, but it was a small amendment to it. This is really, technical stuff here, and maybe I'm remembering wrong, but it was kind of a moderate a Democrat from Indiana who was the sponsor of the bill. Might have been Birch Bayh, I don't know. And it was to allow electronic, use, electronic storage of safety data sheets,
Right.
then called material safety data sheets. And so I suppose you could say, if I were your lawyer arguing keep the Hazcom rule, that by acknowledging the rule and making a modification to the rule or directing a modification to that rule, maybe that rule is congressionally approved.
Okay.
But we don't have that for the vast majority of the OSHA CFR. And, if this non-delegation doctrine litigation is successful, you're going to have that CFR shrink from being, 3 volumes basically covering general industry and construction. And yes, I know there are other ones for maritime and agriculture too, to probably be in one thin volume the size of, a rural Pennsylvania phone book, that kind of thing. And the same thing goes for MSHA, because the same general authority to do rules exists in the Mine Act, which was their organic statute passed in 1970. And they did a very similar thing, which was there was a body of advisory rules out there from the Bureau of Mines. They had a small department called the MSHA, the Mining Enforcement Safety Administration or something. To my knowledge, they rarely did any kind of inspections. They didn't really have that ability. And I think if you violated one of these, it might have been a $10 fine. And what MSHA did was they took all of those Bureau of Mines rules and they recodified them under Part 55, which no longer exists, 56 and 57. And that became the metal and non-metal rules. They already had some coal rules that they were able to move over. But since then, there's been one time when Congress has told MSHA, thou shalt promulgate rules.
Mm-hmm.
And that was after the Sago mine disaster and the Aracoma mine disaster in 2006. We had a very unusual thing happen, which was we had a Republican president, a Republican-controlled House, and a Republican-controlled Senate. And within 6 months of that mining disaster, they passed an amendment to really strengthen the Mine Act. You'd never see that on OSHA because would be so much lobbying opposition from the business community, but the mining community is much smaller.
Mm-hmm.
And so they directed MSHA to promulgate a few rules, mostly dealing with underground mines, communication systems, and also they changed the immediate reporting requirement for all mining operations. And so, again, we have a little handful of rules that were directed by Congress. But the vast majority of the MSHA standards, including notably their Hazcom rule, which is quite different from OSHA's Hazcom rule too, maybe we'll talk about that. All of those are subject to potential rescission, voluntarily, I think, by the agency, which is very much in lockstep with this whole idea of deregulating it. We're seeing this on a lot of fronts. It's not limited to OSHA and MSHA. And in fact, probably, less damage has been done there to date than we've seen, for example, at EPA, where they've had, I think 50 rules rescinded already, or the Department of Education, which has had a bunch of programs terminated, or the EOC, which is basically, I teach employment law as one of my many side hobbies. And I set up my platform again last month for the new semester, and I was checking all my EEOC policy links. They're all dead.
Oh,
They're all
wow.
gone. Yeah, so I had to kind of restructure my course a little bit, which wasn't something I was anticipating at the last minute. But, it's coming. This regulatory review that they're doing, which is not just looking at non-delegation, but it's looking at a variety of factors. And they all stem from President Trump's executive order, by the way, on deregulation. So it's not like OSHA and MSHA are making up this criteria.
Right.
This is government-wide. It just happens to be affecting the agencies that we know and love that, I fight with all the time, but I know that they save lives. I know that there's a need for these regulations. And as a safety professional, I'm always, coaching my clients, because sometimes I'm the only safety professional that they've met for small businesses, of the importance It's not just Mickey Mouse compliance with what's in a book.
Mm-hmm.
These things save lives. And Hazcom is one of those standards because I've handled, accident cases where, shall we say, adherence to Hazcom would have made a real difference in some people's lives.
Oh, sure, sure. And that's, the crux of the whole reason I started the podcast. So, with the Hazcom standard potentially getting killed, do you think this could open the floodgates for tort law and personal injury lawsuits without the exclusive remedy of, let's say, workers' comp?
Yeah, I mean, this falls into the category of be careful what you wish for because you might get it. The same manufacturers who are going, hey, get rid of that Hazcom rule. That's a pain in the butt. It's number 2 most cited standard. It's paperwork intensive. It's a gotcha game. That we've heard all the arguments. If they are manufacturing hazardous products, especially those that contain hazardous chemicals that can be released upon use, they rely on Hazcom as their insulation from tort liability. And I did a paper years ago for the American ASTM International dealing with this issue, and it's the whole sophisticated user concept, which is if the manufacturers do their due diligence and they communicate, no BS, they communicate what are the risks of this product, what do you need to do to use it safely, what PPE do you need to use, and let's circle back to that in a moment here on respirators in a bit. But, what PPE do you need to use? What are the precautions? If it gets in your eyes, what do you do? If you swallow it, what do you do? What are the permissible exposure limits? And, half of these chemicals that are out there these days aren't regulated by OSHA under the Z tables.
Mm-hmm.
I mean, they tried to update 428 substances in one rulemaking back in the early 1990s, and they got shot down by the court. And since then, they've updated a handful of their industrial hygiene standards. But, the OSHA PELs are very out of date in a lot of cases. So what do you do? If you're a manufacturer, you're on your safety data sheet, you are putting the NIOSH RELs, you're putting the ACGIH TLVs, you're putting German standards or, Australia, New Zealand, whatever is out there applicable to your product. And with those robust warnings, I'm going to call it, the courts have held that then when those sheets are shipped, I have to say that one carefully, downstream to the purchaser, the expectation is that the employer has the legal obligation under Hazcom to review those safety data sheets with the workers who are going to be using those products to make the personal protective equipment available. If you have to wear a respirator, you're wearing a beard that you can wear a respirator with, and so on and so on and Scooby-Dooby-Doo. If you're supplying gloves to people, that it says it should be, gloves that are impermeable when you're using a certain level of chemical and not canvas work gloves, those kind of things. That's basic information that you glean from the safety data sheet. And so in a world where all works well, that information is communicated by the employer to the employees. The employees, of course, never do anything wrong. They always follow the safety data sheet, and nobody ever gets ill and nobody ever gets injured. And of course, one of the disconnects can happen when the manufacturer sends, right now, for example, there's a lot of attention on the engineered countertop issue. And I can't get too deep into the weeds on this because I am a little bit involved with the issue. But the short thing is, their argument has always been, the manufacturers, that they have, when we do it ourselves, we follow our safety data sheet. We've never had anybody get silicosis. And then they sell the materials to, say, a big box store. And sometimes they fabricate there on site. Okay, so far so good. The Lowe's and Home Depots of the world, they do Hazcom training for their employees. Right? Yeah, they do, right?
Let's hope,
We hope
yes.
they do. We hope they do. and they've got the safety data sheets in hand, and so we're all is well. But the problem is when you have the, 5 guys in a truck size company, and they don't buy enough stuff to have corporate accounts. And so they go to the big box store and they buy this stuff off the shelf. And they're not necessarily getting the safety data sheet with it.
Right.
Now, again, the manufacturers, and this is both smart and legally efficient, they put all that information out on what? Their websites.
Sure.
And it's not just ones that, manufacture, countertops. It's, paint, it's wallboard, it's, caulk, it's whatever, and so if you get a product and you buy it at, off the shelf at wherever, you get some spray paint at the 7-Eleven, whatever, you have a way of going, because the manufacturer's information has to be on the product label. We know that. That's part of Hazcom too. And so they can go to that manufacturer's website. They can download the safety data sheet. In the case of these countertops, they also have videos that are out on YouTube and on their website showing proper, methods of cutting and installing and water and, ventilation and all the good stuff you should be doing. So it's not like the if the safety data sheet is not transported with the product, that means you're SOL, and I don't mean statute of limitations. You still, as an employer, have a way of capturing that information to share with your workers. Having said that, I've defended countless Hazcom citations over, more than 30 years of practice. And, sometimes it is for the Mickey Mouse BS, you had the Duron paint and you were using Benjamin Moore. Who cares? I mean, I care. We care. But, that's a kind of a small error or omission. Chemical lists, a chemical inventory list. Nobody ever does those, right?
Mhm.
Sorry. But, on this point, what I find are, I'll put it this way, employers fall into 2 camps. There's don't know and there's don't care. And the real small guys, sometimes they just don't know. It's like this paperwork came with the product, but they don't really understand what they were supposed to do with it because they don't even know what OSHA spells.
Right.
And then you have other companies that are, well, if I tell them that they have to wear a respirator when they're using the spray paint, they're not going to work for me because they're not going to shave their beard. So I'm just not going to tell them that they need to wear a respirator. And, as the old Tower of Power song went, it's not the crime, it's if you get caught. Yeah, we're seeing a lot of that these days, aren't we? But the bottom line is, most employers understand the Hazcom rule somewhat poorly.
Mhm.
And I do Hazcom training. I do most of it because I'm, as a mine safety professional, I'm still an MSHA approved trainer. So yay me, and, as I said, their rule is a bit different, but, their rule is less stringent. Their rule is less protective. And MSHA essentially has said, we're not going to do another rule, but if you follow the OSHA rule, we'll accept it.
Mhm.
And so when I do training at the mines, because the OSHA rule is more protective, and it's also aligned with what people are actually seeing now on the safety data sheets and on the product warning, because the old MSHA rule, there's no pictograms, none of that. They still have material safety data sheet in
Sure.
their CFR
Wow.
rule. But when I do the Hazcom training, I'm still just doing the high points. I'm not able to do the deep dive with the guys or gals in the field who are using ethyl methyl death,
Mhm.
and go over it with them. And, my clients are kind of, well, as long as we don't have to keep the binder anymore, and we can just, if there's a problem, we can just get online and look up the safety data sheet. Okay, cool. And that's okay. And that's allowed. Until the time when you're on a night shift and the computer is locked up in the foreman's office, and then you have no access to it at all.
Big time
So,
citation. Yeah.
redundancy you know, redundancy, Department of Redundancy. There's a basis for it at times, and when you have people, again, I do a lot of work both with mining and construction. I do stationary stuff too, but a lot of the stuff the people I work with are transitory. There's a lot of portable sites. There's a lot of mobile sites. And, is it practical to carry around a huge binder of safety data sheets with you because you have to use 3 of the chemicals that are in there? Probably not. However, there's an awful lot, especially greenfield construction and some of the more rural mine sites. There's no phone service. There's no computer, back, they'll have something wired back at the office, but the guys who are out there, I do heat illness training too, and I've been, shouting out the very, very good NIOSH OSHA heat illness prevention app that they have. And people download it on your phones, I say, and I'm telling you all that too. But I have people tell me, well, where we're located, we don't get a signal. We can't use it. So those are the problems, when you're relying on technology too heavily and then the technology fails you. What do? If you have a power outage, or more to the point, if the internet goes down, maybe the power is still on, do you stop work? I mean, this is a legit legal question. If you are relying solely on computer access for your Hazcom information in an emergency and the computer goes down, what then? Do you stop work? Because otherwise, if you say no and you allow people to continue using chemicals, what then? What if somebody does ingest what they thought was Gatorade and it turned out to be antifreeze? What if, as I told you when we were talking earlier, somebody gets cement dust in their eye? Do you take them to the eye wash station or do you put gauze over it and take them to the emergency room? And, in the case I had, the fact that they didn't check the safety data sheet on that project ended up essentially blinding this guy, in one eye for life because of the pain from it turned the cement dust into concrete in the back of his eyeball. And I went back and checked after we talked about that earlier. He ended up having to have the eyeball removed.
Boy.
Because there was no way they could
do anything.
Ease the pain otherwise. I mean, you think about getting dust in your eye. Okay, what would the safety data sheet have done? In addition to the first aid, it would have told him to wear goggles.
Mm-hmm.
I mean, these are life-changing injuries.
Sure.
I deal with a lot of safety accident cases where people have their fingers and arms amputated and, they get crushed between mobile equipment. And, that's very dramatic stuff. But the consequences of a Hazcom failure can be a lot more, subsurface and involve latency periods where people don't even know that they're going to become ill until 5, 10, 15, 20 years later because the safety data sheet wasn't followed. And, that's the reason when you don't see immediate consequences, sometimes it's hard to really appreciate why the rule is important and what the long-term consequences can be. If I get a chemical burn on my hand, I'm aware of that, bad boy. We're doing something about that. And if I get the dust in my eye, but what about the inhalation hazards?
Chronic stuff.
And not knowing the right levels of protection for a particular product, is legit a criminal offense, in the worst case scenario. And, I've had some cases where, they had a bunch of contractors on site and suddenly everybody smelled chlorine and people started going down. Now you're outside of workers' comp. Now you're into tort litigation when other people are becoming sickened or even die on your property. And, speaking of chlorine, I had another one of these where it was at a camp. And of course, I won't mention the organization, And they had young teenagers, counselors, who put too much chlorine in the pool. And they were overcome, and I think there were 10 or 12 kids who were in the pool when this happened. They all went to the hospital. And you can only imagine, and not only did we have fun with OSHA in that particular case, they did a cross-referral to the EPA, and then we had to deal with a 50-page questionnaire about a chemical release and, map out all the residences that were within 10 miles of where this body of water was, which happened to be a concrete swimming pool, like the Beverly Hillbillies, the concrete swimming hole. And everybody was okay. But, it was the smell of it, I think, sickened some of the kids. And I think somebody threw up in the pool, those kind of things. But the immediate counselors who were in closer proximity to what they were doing, they were sickened worse. And this, this is the kind of stuff that sickens me, because I'm already, a bear when it comes to child labor. And then when you have people who are under the age of 18 and they're handling hazardous chemicals and they're exposing other people under 18, to this, and they never heard of a safety data sheet, and after that, I happened to be up at my community pool that summer, and we, of course, have young lifeguards who work that, and I asked them, so what are you doing about Hazcom training? And you know what I got? What's that?
Right.
So I did a little impromptu Hazcom class for the counselors that day, and I also went into my community office and I said, you hired the pool company, but we have liability here too, and had them express my concerns. And I hope they straightened it out, but we'll see. The pool will be opening again here next month. It'll be a whole new crop of counselors, and maybe I'll be putting on another class in my bathing suit. Who knows? Hazcom never sleeps, right?
Right. And that's an important point. I mean, with the way we're going, and GHS is supposed to be a globally harmonized standard, right? And across the board.
Yes.
Yeah, right. You can see where I'm going with this. The U.S. has been notoriously behind with trying to adapt updates to the revisions. With your ear on the ground in D.C., what do you see as a bottleneck keeping us from staying current with the rest of the planet?
Well, it's hard to adopt new regulations when you're trying to, at the same time, undermine all the existing regulations. GHS is a particular area of interest for me, because I do work with a number of multinational companies, and they welcome the adoption of GHS, because truly the whole idea was to globally harmonize our Hazcom system. And by the time that we adopted the first GHS rule, which was in 2012, it took so long to get that rule finalized that it was already obsolete by the time it was codified. The other, that was the third iteration, I think, of GHS that was adopted. The rest of the world had moved on. And in fact, we were also out of sync with the Department of Transportation in the U.S. and the EPA. So those two U.S. agencies had gotten out ahead of OSHA on this. Meanwhile, I was just sitting back there kicking rocks, doing nothing. And, OSHA got the rule. Okay, fine. We're now all saying safety data sheets. Let's repeat it. Safety data sheet, safety data sheet. And, here's some pictograms. Okay, let's talk about those. And here's some signal words. Let's talk about those. Okay, that's cool. We've got now a formatted safety data sheet that is all going to look the same. That's great, because as somebody who used to have to read safety data sheets that were all different forms, I used to want to drink the Gatorade myself at the end of the day. So 2012, okay, well, we're behind the rest of the world, but not that much. And then, the GHS meetings continue. I used to be the federal representative for 25 years for the American Society of Safety Professionals. And part of my portfolio there was representing them at these GHS meetings. Sadly, I didn't get to go to the ones in Switzerland. But it was cool. They used to hold them at the Canadian Embassy in D.C., at least up until COVID. And so I got to go over there and feel a little Canadian once in a while. And, the discussions were fascinating because we get very myopic here in the US that we think we have the best ways to do everything and we have the market cornered on knowledge on everything, and of course we don't. And so hearing, not only hearing the discussions about the next evolution of GHS, but also talking to others from around the world. And, how are you doing chemical management? It was really what got me very excited about the idea of control banding, for example. And I saw, boy, we get in sync, we get up to date on Hazcom, and we adopt control banding, and we don't have to worry about updating the Z tables after that. This gives us the tools that we need, very much like the UK uses, in their programs, and the EU, International Labor Organization. All of that is geared kind of toward that. And, of course, control banding never happens. Every time we have a change of administration, there's a flavor of the month. And I remember right before, the turnover in this particular case, NIOSH had a big might have even been a 3-day conference on control banding in DC that I attended. And I really, there were a bunch of OSHA people there. Everybody was like, yeah, very gung-ho on it. That is a duck. That is a duck. And, it never raised its head again. So I still think that ultimately is the way we have to go. But to do that, we have to have a robust Hazcom program. And so, okay, we updated it again, finally, with the 7th iteration. Now we're kind of in sync with DOT and EPA, but we're still out of sync. We're still lagging behind the rest of the world. And, in the short term for American businesses who are only selling in America, who cares?
Right.
I mean, is there a better way to do things? Yeah, probably. Otherwise, the UN wouldn't continue to be updating the model GHS program. And this is aspirational. I mean, I want to make that clear. It's not that, and people on your podcast probably know this, but when the UN did this way back in Rio de Janeiro for World Earth Day, I think it was, and we're doing this one at an appropriate time, I suppose, doing it this month. It was with the idea that this was not going to be forced down the throats of the UN members, but it was highly recommended that they adopt it, for their countries as they felt appropriate, work it into their regulatory systems. And I remember it being explained as a set of building blocks where you can take what you need and you can leave the rest, if they're incompatible with your legal system or how you're otherwise doing things. But it really is the way to go. And, if you are trying to market your products overseas, or if you are, a company from other countries who have operations in multiple countries, I always come down to this. How do you justify providing U.S. workers with a lesser level of protection than you're affording your workers in your other countries?
Right.
Now, if they're using child labor in China, that may not be a consideration. But, for the countries that are reputable, for the countries that are conscientious, that care about their workers, and many workers in many countries in many ways are better off than U.S. workers are, in terms of protections in some areas. I'm always shocked when I have to look at Australia and New Zealand at really how robust their protections are. We would be well served, to do a little bit of exchange with them and maybe see what they have that might be worth picking up. Because even I've looked at weird stuff like demolition, and they're just out there so much ahead of us. So that's my takeaway is go to New Zealand, go to Australia, go in our winter because it's summer there. And, a fact-finding mission. You could probably get your employer to pay for it.
And pick up some best
you
practice.
Bring a lawyer with you.
Yeah, there you go.
But, again, I don't want to belabor this, but you get my point. And if you are a manufacturer and you're putting out warnings, you want those warnings to be applicable worldwide. You don't want to have one set of dumbed-down warnings for the U.S.
Right.
But you also, if you're going to, kind of have a unified message, one set of safety data sheets one set of Hazcom information that you're sending out worldwide, it's got to be benchmarked to the most stringent, the most protective, in other words, standard. So that information is great, for those employers who are sending that, or the manufacturers rather, who are sending that. Then the task falls with the employer to make sure that the workers understand that information. And I will note, multilingual versions of safety data sheets are available, boys and girls. Don't even think about using as an excuse as to why, Jose died from inhaling poison, the fact that, well, he couldn't read English, because it's your obligation, to make that information available. All training has to be done in a language and a vocabulary that the workers can understand. Sometimes as a lawyer, I have to deal with the vocabulary part of that because, I can throw in some words that even I don't understand sometimes. But really, I mean, they're serious about that. The whole idea of training isn't just to check a box on a form. It's to make sure that your people can do the assigned tasks safely. They're not going to, and healthfully, and they're not going to injure themselves, and they're not going to injure others. And, when you're dealing now these days with multi-employer work sites more and more often, coordination of those Hazcom programs is critical as well, because your people may be in spacesuits, but if you've got a downstream contractor and, your ethyl methyl death is blowing in their direction and they're sitting out there, with bare faces, I'm sorry, you do have an obligation, even if you're not the controlling employer. OSHA calls it they have the controlling employer, they have the creating employer. That's the one that creates the violative condition. Then there's the exposing employer. That's the one whose downstream guys are being exposed. But sometimes that creating employer thinks their obligation is done as long as they protect their own workers. And that isn't how it works. If you have other people in the zone of danger, you have to protect them. Should have brought my tea here.
So we touched upon this a little bit earlier with the Z table conundrum. And, many of our exposure limits, they're based on 1960s ANSI standards, right? And if a chemical is legal according to the Z tables, but known also to be hazardous, where does the employer stand on defending when they're trying to follow the law, but still sees a worker get sick or exposed?
Well, let me say this about that. One of the rare uses that I have seen of OSHA's general duty clause, where there is a codified standard, has dealt with chemical safety. And the example I'm going to give you, which is a case, and I wasn't handling it, but I heard about it, and it did end up settling, so it's not a published decision. Not a published decision, but it's called Fiberdome, and it had to do with styrene. And at the time, at least, and I think it's still the case, the OSHA codified level for styrene was 100 parts per million. The Society of the Plastics Industry, of which Fiberdome was a member, had years earlier put out a number of policy documents, guidance for members, saying we all as an industry recognize that 100 parts per million is not safe for workers in our industry. And as an industry, we are recommending that you maintain exposures down to 50. Okay, so fast forward, Fiberdome is out there doing their styrene manufacturing, and OSHA shows up, and they do some sampling. And the samples at issue in this case were at 75 parts per million. Well, they were in legal compliance with the codified OSHA standard, but they were, 150% of the standard recommended by their industry group. And under the General Duty Clause, which is Section 5A1 of the Occupational Safety and Health Act of 1970, you can be cited if there is no standard that exists. but there is a recognized hazard, recognized by the employer, to which its own employees are exposed, and there is a risk of death or serious physical harm, and there is a feasible method of abatement. And when you look at OSHA's Field Operations Manual, which is their guidance to the inspectors on how to write citations, one of the things in the General Duty Clause they look at is industry recognition. And so it was this industry recognition prong that they cited Fiberdome, and I remember reading this and going, well, that ain't right. If there's a codified standard, they're kind of stuck with that. And I went back and I found there was an old case, and I want to say it might have been General Dynamics. So it was back in, not long after, it was last century. I'll say that. I'll be safe saying that. Where they had done something similar, where again, and in some cases, the employer's own documents reflect that. If you say we're not going to expose people above 50 parts per million, and you're allowing them to be exposed at 75, can OSHA enforce your policies? No. But what they can do is say your policies reflect the recognition of a hazard and that additional protection was needed beyond the codified standard. So that was the rationale there. And when this case first came out, I thought it was going to be, a headline, banner, go to the Supreme Court on this one. And no, they ended up accepting the citation and paying it, which says to me, how many times has that happened around the country that just, didn't make the papers,
Right.
and, but for even being kind of clicked into the association community, and reading a lot of association magazines, I might not have even known about this initially. So, there is one example, but, if that, the existing exposure limits are not sufficiently protective, is your legal obligation done? Maybe yes, maybe no. Is your moral obligation done? Well, if you're kind of asking this question, I kind of question your ethical code to begin with, but I'll give you a great example, which is on my mining side. As you may have heard, MSHA was finally updating its respirable crystalline silica standard to lower the exposure limit from 100 micrograms per cubic meter, which is the current PEL, down to 50, which is the OSHA PEL. And the rule was finalized under the Biden administration, scheduled to take effect in April of 2025 for the coal sector and April of 2026 for the metal and non-metal sector, which is the majority of mining. There's, almost 13,000 metal and non-metal mines, and there's less than 1,000 coal mines left. So you can see there's a bit of disproportion there. And, of course, the business community sued over the MSHA rule. And I will say quite rightly, not because of the PEL. Everybody's kind of agreeing in the end there should be a 50 PEL, but because of other things that MSHA added into the rule kind of at the last minute after the proposed rule and things, they just loaded up the Christmas tree. But what happened is MSHA first stayed the rule last year, and now just on April 6th, pretty recent history here, April 6th, 2026, for those listening in the future, MSHA put a thing on their website announcing that they were indefinitely staying the implementation of the rule until the litigation sorts it out. What I think is going to happen with that litigation is, I can't say this officially, I can only say it unofficially, is that MSHA is going to pull the rule back, and they're going to repropose it in a new form. And I think that's, in the end, a good thing. But we do have this issue now where we've got a whole subsection of our working people who have relatively high exposures to silica, and they're being allowed to be exposed to a Group 1 human carcinogen at twice the amount that the U.S. Court of Appeals D.C. Circuit found to be consistent not only with lung cancer, but silicosis, pneumoconiosis, COPD, emphysema, pulmonary fibrosis, renal disease, and autoimmune disorders.
Right.
But wait, there's more. You also get a toaster. I mean, this is crazy that we all agree people should only be exposed, to 50 or below. And I can't even tell you how many companies I work with that are, well, we don't have to really start doing the sampling, and we don't have to really start doing the da for now, and we'll wait and see what the new rule's going to be. And, I speak somewhat directly to my clients, and it's usually like, dude, do you not care about your workers? That's kind of the first thing. And dude, 20 years from now, you're going to have an explosion of workers' comp claims and maybe tort claims because you're using half of your people out here. You're calling independent contractors under the new Trump rule, new test, because they just killed the old independent contractor rule from the Biden administration. So, we're back to, if you could pick the hours you want to work and you're making any money off it, pretty much they can call you a contractor, and again, companies sometimes will step over a dollar to pick up a dime and don't see that in a mining environment where you're exposing people to, not only, a human carcinogen, but a bunch of other chemicals and, coal dust, relying upon an obviously outdated rule, where people are going to get sick and 20 years later, they're going to come back and they're going to trace it back to working for you. This doesn't make sense. I mean, I had this, I'm venting here, but, I had really an hour long, I'll call it a bit of a knockdown drag out with a client last week where I was trying to convince them to go ahead and put an occupational health program in place now. And they're saying, well, we don't have to yet. Why should we do medical surveillance?
Oh, boy.
Why? Why? Let me tell you the ways, but they can pay me for my advice and they can ignore my advice. My fingerprints aren't on anything. It's the people who are making these decisions in-house who I think should be a little bit concerned. If you are knowing and willfully allowing people to be exposed well above a PEL for any substance because you can get, or you're meeting the PEL, I should say, but you're allowing them to be exposed well above the recommended exposure limit or the TLV, how do you justify that? Some of these companies have family members working there, and I think to myself, well, I guess they don't like their family very much. But I will be the first to say ACGIH, it's not a transparent process. They definitely go overboard, on some of their recommendations. Right now for silica, for example, it's 25 under the TLVs. There's no workplace in construction or mining that's going to reliably be able to be below 25 consistently. So, you get down to that, you're looking at shutting down whole segments or having everybody in a PAPR all the time,
Right.
and that's not really feasible either. So
What do you do?
there's, but when you have these resources against which you can benchmark what the proper exposures are, and you get that information, go back to Hazcom, because that's what we're talking about here, from the safety data sheets, use that information. Don't ignore that information. Don't go, cherry picking. Well, here's that one limit. Well, okay, we don't have to do anything on this yet because, more brilliant people than me have looked at the epidemiology on the particular thing, and I don't know. It is very frustrating. I talk about silica a lot because, jokingly, I live and breathe it, and we all do breathe it because it's a ubiquitous substance. It makes up the Earth's crust, but it's the overexposure, folks, that's the problem. Not sitting at the beach, or you're okay at the beach. But I look back on that, and when the OSHA rule came out, they're trying to do this. I said, guys, NIOSH recommended a 50 exposure limit back in 1994, and you're complaining that it took them, 42 years, whatever it was, for OSHA to finally adopt it. It's not like they're rushing chemical rules, and doing it with wild abandon. I mean, The recent rules that OSHA has done, hexavalent chromium being probably the last one I did any meaningful work on, but there was a lot of thought that went into crafting that standard, and there's a lot of controversy still about hexchrome.
Sure.
But, it's also the chemical that, made Erin Brockovich famous that was in the water. So it's not just a workplace concern, it's a public health concern. And there, you probably didn't have a question for me on this, but I'll throw this in gratuitously. If you are complying with the best controls, if you are using your safety data sheets and looking at how to protect your workers, but also, how to, what levels you need to keep air emissions down to, that's also going to help you with the NIMBYs, the not in my backyarders. And conversely, if you are a company that has a history of chemical violations, whether it's EPA or OSHA, and Hazcom, which ties in with the EPA's risk management standard and, community right to know. Remember, that's how it all started, community. And you want to start a greenfield operation in, Peoria, and they see that, in 5 other locations you've had in the state of Illinois, you've had citations from OSHA for violations over and over again of the Hazcom standard. And you've had maybe injury reports. And again, with the electronic record keeping, things are more transparent now. You've had people who've had chemical poisonings. Okay, are you a good community citizen, potentially? Do we really want you in our backyard? And people are always concerned about the impact of their OSHA citation history on their future OSHA citation history. And they have blinders on over the fact that both OSHA and MSHA, your citation history is very transparent. And you can get these files through a Freedom of Information Act request. And, not only that, but if you are sickening your workers, that becomes your reputation in the community as well. And these days it's harder and harder to attract qualified workers. So,
Sure.
You're narrowing your pool. If you're an employer who don't care, you're narrowing your pool of applicants to the workers who don't care.
Yeah, right.
And if, as I like to say, when you have a new workforce graduating, mamas don't like their babies to work for companies that poison their workers. And so, mamas are doing a little bit the citizen sleuth approach to things. That extends to looking at OSHA and MSHA and EPA websites as well.
Sure.
And a lot of times, the complaint letters come as a result of that type of independent private research, as to what's a good company, what's a bad company. We won't even get into the whole SEC, and if you're a publicly traded company, what does that look like on your track record? But, if you have a pattern or a practice of poor adherence to Hazcom, it can impact you adversely in a number of ways that I think go well beyond OSHA. And that's really kind of in the message today.
Right. Well, you talked earlier about like PPE, and a lot of people seem to treat PPE assessments, personal protective equipment and chemical inventories as 2 different folders, right? Could you explain why a failure to integrate like Section 8 of the SDS, the PPE section, into PPE assessment, would that be a potential smoking gun for an OSHA inspector?
Yeah, it sure would. And again, if you go back to their field operations manual, which is their instruction guide for doing inspections, one of the things that they tell inspectors to do if they're doing a wall-to-wall inspection is to ask for their PPE assessment. It's 1910.132. Most of the time, the employers I work with go, "What's that?" And how do I do that? And when I'm guiding them, because a lot of times I do assist with figuring out abatement on citations, it's very simple. Okay, let's look at what are you doing here functionally. Okay, are there safety hazards that require you to flame resistant clothing, things like that? Is there a specific hard hat you used to use or you have to use? Is there electrical exposures? Can you use a bump cap? What can you use here in this situation? Because those aren't really hard hats, and there's all newfangled designs, and that confuses things too. I had one guy who was always wearing the cowboy hat
Boy,
style hard
right, I've
hat.
seen that.
And did that mess with the inspectors? They never thought that it was a legit one. And my point is, you want OSHA and MSHA to just move on through. You don't want them to start asking a bunch of questions, So it's like, having a blue stalk on celery or something when somebody's wearing a cowboy hat out in the field, around a crane. But, I digress. You're looking at beyond the safety hazards, then you have to move to the chemical hazards. And where do you find that information? You find that on the safety data sheet. And that's where it tells you whether you do have to have chemically impermeable clothing. Do you have to wear safety glasses, or do you have to wear goggles with side shield? Easily, I've handled a dozen citations over that in the past. Well, I don't understand why they cited us. They were wearing safety goggles, the safety glasses. Well, did you read the safety data sheet? There's also people who think regular eyeglasses are safety glasses too. Not the fact. And I will note that this is an aside here, because I think it's good to share this. Number of years ago, I used to play on a softball team, and I didn't wear regular glasses back then, but I wore my work safety glasses, which were sunglass type, out in the field. And I happened to catch a ball. I was playing second base. I caught a ball in my eye.
Oh,
And my safety glasses saved my eye. I had a black eye, but they did not break. And if I had had over-the-counter sunglasses on, I'd be blind today in this eye, and I never forget that, So the things that you learn on the job about PPE, carry that with you off the job. Wear the hearing protection when you're operating your lawnmower or power tools at home. Wear the safety goggles. Because the other thing is, if you have good habits on the job, but then bad habits off the job, it's easier for those bad habits to encroach into your on-the-job practices. Sure. So have it flow the other way. But, the bottom line is, there is the expectation that you are, as an employer, or whoever it's delegated to by the employer, is going to look at the safety data sheets for the chemicals in use there. And that is going to factor in to your PPE assessment under 1910.132. And if you do that exercise and OSHA, looks at it and finds it lacking for whatever reason, you're able to explain to them why you made the choices that you did in terms of the PPE, because they may be wrong on it. They may think you need to wear side shields for a particular task, and you don't. But you'll be able to defend your decision. And then, of course, the ancillary to that, lawyers always have to have that, is when new safety data sheets come in, who in your company is comparing them to see if there's been any product changes, chemical composition changes, PPE changes? You need to review these annually or as things change. And so you may need to update that PPE assessment more frequently based upon changes. Maybe you switch from one product to a different product because it's cheaper, but now it has different chemical hazards. And this is, one of the trapdoors that I find employers fall into, is just assuming products never change.
Right.
And so, we're relying on retrieving these from the computer anyway. And so when they come in with a product, they just toss them in the trash rather than really sitting down. And of course, manufacturers can do everybody a large by having the date on the safety data sheet that it was revised, and some do, some don't.
Some don't.
So that does make it more challenging, for sure.
Yeah. Excellent. Well, that's some great advice, and gets us into what we talked about earlier with the dusty binders, right? And what do you do with binders that are full of torn, yellowed SDSs? And you're defending an employer. That physical paperwork often translates to a liability nightmare, right? During a deposition. What then? What do we do?
Well, we have these things where you can scan documents. There's that option. But you raise a point, which is you can't just take everything and throw it out, because there is a document retention requirement for safety data sheets as well under the employee access rule, as well as, in the Hazcom standard. And boy, this scares the bejesus out of me, because if you're just relying on the latest version that you're downloading from the computer, you aren't in compliance, because, Billy Bob, who worked for you 5 years ago, was exposed to a different formula of that product. And if you didn't save the safety data sheet that he was exposed to, and then he develops ethyl methyl, some kind of cancer, and says, I was exposed on your watch, and you're pulling out a safety data sheet that, post dates his employment there by 5 years, the whole idea of maintaining these is so that with the long latency period of many occupational illnesses, somebody will be able to know what they were exposed to and when. And if they changed it, and, the manufacturers do change their formulations many times to make things safer.
Sure.
Look at asbestos,
That was safe at one time. Yeah, right.
Yeah, well, it was a safety product. It was a fire prevention thing. And look, believe me, I lived in a 1920s house. I'll talk to you about asbestos floor tiles sometime, and insulation. But, these are things people don't think about, is the duty to preserve these documents, and to preserve them in a form where it's retrievable. I'm old enough that I had the hard floppy disks, as we call them.
Yep.
And when I changed firms back in 2000, I brought 300 of those disks over with me, and, never looked at one, I don't think. But when I was closed my firm and I went to work for Littler last year, I realized, okay, here's this little box of these. I did not own a single computer. My entire law firm nationwide did not own a single computer where I could play one of those. So I did the if I haven't needed them in 25 years,
get rid of them.
But if I had Hazcom safety data sheets on those,
they're gone.
What then?
Right.
What then? Or, any media. We all thought CDs were going to be, forever.
Right.
And, let me tell you about some of my mixed CDs and the dropouts on them now. And thumb drives, okay, we can put, 128 gigs on a little thumb. That's great. What if it gets lost?
Done. Yeah.
You save it to the cloud. What if that cloud service isn't around 10 years from now? So these are things employers really need to give some thought to. And, as much as I hate to say it, those old dusty binders, put them in a box, label it, put it in your storage, let people know where it's stored. You don't have to throw them away.
Right.
But, if you choose to scan them and store them electronically, just be mindful of the fact that as technology changes, you may need to copy those things over into a different format, to make them available.
Sure. Well, it's been a great conversation here. We've gone through some excellent topics that, we don't always think about behind the scenes. And I'm so thankful to have a lawyer on the show today, because it gives us the gray areas to talk to. Do you have any final thoughts as a takeaway for the audience?
Well, just this as we mined all of my considerable knowledge here. Guys and gals, this is the number 2 most cited OSHA standard. And at least for the last 20 years, to my knowledge, it has either been number 2 or number 3 on the top 10 hit parade for OSHA. Why is that? It's because it is very paperwork intensive, for sure. It's got a lot of moving parts. It's got a training component. It's got, historical record component. It's got the safety data sheet component. It's got the chemical inventory list component. It's got the labeling component. It's got the temporary container component. But that they look at it. It's the number 2 most cited standard. And so in terms of a return on investment, putting some time and energy and thought into having a working Hazcom program, a compliant Hazcom program, is going to be, worth that time and money. These may not be the most expensive OSHA citations, but can they be? Yeah. Have I had expensive ones? Yeah. Does it lead to other things? Yeah. The most expensive OSHA case I had was $500,000 in penalties, and it had to do with lead exposure. And although the citations were all issued under the lead standard, they got a few, the Hazcom element of it can't be ignored as well.
Sure.
And they could have saved $500,000 if they had done Hazcom training properly, because it all came down to the wrong respirators being used. And this is where you get that source information. And if you're following the safety data sheet, you're in a very defensible position if you have, an God forbid, an accident case, if you have a workers' comp claim, if you have a wrongful death or tort injury claim from a contractor who was on your site. But, you really have to put the time and the energy into this. This is a rule. It's not an annoyance, and it has a purpose. It saves lives.
Sure.
It prevents people from illness. It prevents people from injury, and it prevents people from suing you out of business if you do it right. So that's probably a good way to end it.
All right. Well, thank you for that, Adele. And listeners, we are thankful and to all of you. And if you want to learn more about Adele's background, visit the Hack Your Hazcom website, and where you can find her contact information. I'm sure she'd love to hear from you if you've got questions.
Always.
Absolutely. And thanks again, Adele. It was a pleasure to have you on.
Thank you. Be safe, everybody.